Hi Karabo, how are you?
I'm good, how are you?
I'm fine. Thanks so much for speaking to us. Yesterday we spoke to Sam, who gave us a quick rundown on amaB's RICA challenge case, and it would be great if you would just give us a few highlights from court yesterday.
Yeah, so the hearings are set down for this week. It's ourselves as well as the friends of the court, and then the state as the respondents. Yesterday we heard from amaBhungane as applicants, and our counsel set out the key arguments for why we want to challenge RICA and what you want the court to rule on. And specifically what you want the court to rule on is the lack of adequate safeguards in RICA, but also the problem of bulk surveillance, which is completely unregulated in our law. That went very well from the presentations that our counsel gave. In the afternoon yesterday, the friends of the court, and that's Right to Know as well as Privacy International, gave their arguments before the court. And they are supporting our application, but they are making a few additional proposals. And that includes saying, so amaBhungane is saying about bulk surveillance. So that's mass surveillance which happens across anybody living in the country, essentially. What Right to Know is saying is that there can never be any circumstance under which this is constitutional, whereas we're saying it's amaBhungane that this should be regulated, brought within law, and there should be adequate safeguards. So I think there'd be some really important, not only proposals, but issues of constitutionality, which were raised by both ourselves as well as the friends of the court.
That sounds really interesting, and obviously we'll be watching this space in the future to see the outcome. But the case isn't finished yet. You're going back tomorrow, is that correct?
That is correct. So we've only heard from ourselves as well as the friends of the court. The state also needs to have an opportunity to present its arguments. Now, so the two arguments which will be presented by counsel tomorrow will be coming from first the ministers, and they will be arguing against amaBhungane's position on the constitutionality or lack of constitutionality of the RICA law. The second set of arguments will be presented by the intelligence agencies, so the Minister of State Security and the various other intelligence agencies implicated or using RICA as a surveillance law. Now, both these two state respondents will be arguing against amaBhungane and the friends of the court's arguments against RICA. They'll be saying things, for example, that this is not a question of constitutionality, it's simply a matter of policy. Now, we say that this is simply not correct. When the state infringes on the right to privacy, not just for journalists or lawyers, but any member of the public, this is a fundamental constitutional right. And so the state, I think, is going to have a really, or at least the state is going to be in a very difficult position to try and make any kind of argument that this is not a constitutional issue, but it's simply a policy matter. So it should be interesting to see how the judge engages with the arguments and whether they're able to put up any kind of robust argument. On paper, it looks like it's not going to be sufficiently strong to counter the kinds of points that we've made.